in Germany 76 years ago, the Nuremberg war crimes trial brought Nazi leaders to justice. And this also was a long, exhausting historic trial that punished monstrous crimes. But still today, I think it influences international criminal law as well as the German narrative of our own history. So the significance back then of the trial was that for the first time in human history, 4 states of very different forms of government and constitutions, namely the US, the Soviet Union, Great Britain, and France, were setting up an international military tribunal with the purpose to hold leading representatives of a defeated enemy accountable for violations of international law. And also in the following years, ever since the Nuremberg Tribunal, there were more international ad hoc criminal tribunals, for example, for former Yugoslavia or the Tribunal for Rwanda. And those, together with the Security Council, paved the way for the creation of the International Criminal Court. So alongside with this court, the United Nations tribunals and tribunals assisted by the UN, such as the ECCC is, which we are discussing today, have collectively advanced accountability issues in a broad variety of areas and advanced also the processes of transnational justice. So coming back to the ECCC and today's webinar, I want to name 3 special features that the ECCC has and that we are discussing today. So first, the composition of the court. It's including judges of both Cambodian and international background with co-prosecutors. So the ECCC combines really Cambodian international judges, prosecutors, and defense lawyers, and applies also the Cambodian and the international law. So this is very special and also brings, of course, obstacles. It's a way of trying to integrate different legal traditions. So I will be very interested to hear from our experts, how was this process carried out, this hybrid process, and could it be called a success? Secondly, what's special about the ECCC is the inclusion of civil society and victims' participation. So the victims were actually able to participate actively in the judicial processes, and civil parties, for example, could also seek moral and collective reparations. So no financial reparations were paid, but in this way, they were trying to contribute to justice also to the victims. But this raises again the question on how national and international NGOs were involved in these processes and what tasks they were fulfilling for the Cambodian society in reaching transitional justice. Last but not least, so the third point I wanted to make is that the meaning of the trial for the Cambodian people and in a broader sense for the international community. So I think this overarching, maybe even a bit philosophical question, can we really achieve justice with putting single individuals on trial that were acting within a whole criminal system? And what can a tribunal provide to these victims? So I want to finish up with promoting again that the ECCC has had many challenges and shortcomings, but nonetheless, I want to end on a positive note and say that it can be also seen as proof that the Kingdom of Cambodia is engaging in a multilateral system with a victim-centered approach and wants to promote accountability and an international rules-based order. And now I'd like to thank again my colleagues Maurizio and also Tim Hildebrand, who is with us today. And they were working a lot on this concept, and I'm very thankful for the honorable speakers and experts we have gathered today from research, civil society, but also from the practical field of the ECCC. And I'm looking forward to a very fruitful discussion.
Thank you very much, Isabel. A very short introduction from myself. I'm Maurizio Pacello, Program Manager at CAS Cambodia. I think to keep, because the clock is running, we'll dive straight into it. Let me introduce our esteemed panelists who mostly have found their way here now. So I would like to start with Mr. Chengpor Un, who is a young and upcoming journalist who has worked on the ECCC for a while now. You may very well have read his pieces in the Voice of America or on Reuters, where he has covered the latest developments over the past week very prominently. We are very happy to have him with us today. From abroad, from Switzerland, we are very happy to have Dr. Julie Bernard. I hope I pronounced that correctly, with us today. She's a senior researcher at Swiss Peace and an affiliate researcher at the Research Institute on Contemporary Southeast Asia, the IRASEC. She's engaged in extensive research on the ECCC and transitional justice in general. And you may perhaps have already read her study on victim participation or one of her other numerous publications. Last but not least, we have Dr. Lee Sok Keang, the director of the An Long Veng Peace Center, who has since 2002 in various positions been involved with the Documentation Center of Cambodia, DCCAM, and has parallelly also engaged in a career as a renowned researcher on ECCC and transitional justice and the reconciliation process in Cambodia. He has written a number of pieces on the ECCC and reconciliation in general. With that, a few housekeeping rules. Please remain muted for the duration of the panel discussion. There will be some time later on for a Q&A session where I would ask you to raise your hand in order to get noted, but to remain muted until doing so, or to utilize our chat. Other than that, after this event, I would like you to please stay in the call for a few more minutes, because we have, hopefully it will work, an evaluation poll that we would like you to fill in and would like to do a short photo shoot. With that, now let us jump right into the discussion. And I would start with a question to Mr. Chengpor Un, and I hope I pronounced that correctly too. The media. Can you elaborate a bit on the role of the media over the past 25 years or so of the ECCC? Has it helped or has it hindered the progress of what the court set out to do?
Thank you, Mauricio. And first of all, thank you, CAS Cambodia, for inviting me. It's been an honor and privilege to be speaking on the same panel with more senior and experienced speaker on the panel. I'm perhaps the youngest and the most inexperienced. I've been working in journalism for some 6 years or 7 years. I'm not sure now. I have to do the counting. But in the meantime, because you know the journalists in Cambodia, we do not have a specialized reporting fields due to the short staffiness. We do cover a lot of issues. So one of my beats is the Khmer Rouge tribunal, but not only the tribunal. We also write about the Khmer Rouge, about the anniversary, the feature, some 2 decades or some many years later after the Khmer Rouge or after the defeat in An Long Veng, where have been the Khmer Rouge right now. So I hope I could speak for many Cambodian members of the press, but to be personally, I only want to speak on my personal experience on the role of the media in this transitional justice process with regard to how Cambodia recover itself from the Khmer Rouge after more than 3 decades or 4 decades right later. Back to square one, media is not there to promote or to hinder the justice. Media is there to report the truth. That very foundation for media to do their job is to ensure that all relevant party and stakeholder have the role, have the opportunity, have a chance to speak for themselves. It's not different from the that how much or how big the crimes have been committed during the democratic Cambodia, you always and you still give the accused a presumption of innocence, have their legal right to defend themselves. Same to us, but to the media. But the difference is the media provide a platform and have a role to report objectively about what happens, giving the opportunity to both the perpetrator and the victim, or in my sense, I prefer calling them survivor, to give them more hopes, the chance to speak, to tell their story. So this is a huge contribution from the journalists and from the media to give all the party the platform, and how you report and how you approach the story is also important. Make sure to giving the Khmer Rouge narrative, the Khmer Rouge story in the newsreel, in the news bulletins is the least that we can do. But in Cambodia, to my observation, the proactive approach to report on the Khmer Rouge have not been frequent. You will see a lot of members of the press flock to the courtroom on the big day of the ECCC, the starting day, the commencing day, or the concluding day. But in the process of 5 or 6 years, or a few years of just a trial process, listening to a huge number of testimony from the civil party, from the witness, from the expert, and from the perpetrator themselves in the ECCC, you don't see a lot of media coverage unless the ECCC made some contribution to buy airtime or to buy the slot in the TV to ensure that those kind of content could reach the people. So that's the concern, because not only because of the media have to find the news angle, the news topic, to ensure that they got a lot of audience, but also it's because of the audience and the interest in the Khmer Rouge topics is you have to be, we have to admit it is fading, fading from the public, especially if you look at how much participants have attended the final appeal hearing of the Kyosampon in the case 0202, it's very low. It's just very quiet. So the public attention and the public's, attention in the ECCC and the Khmer Rouge is perhaps fading. We have to admit that, and that poses a challenge, especially for the private media, to actually just go there and do more Khmer Rouge story for many years. And in Cambodia, there is another specific challenge for the media when it comes to report the Khmer Rouge is how to report it objectively, when the Khmer Rouge narrative have been often, being used as a political narrative, that the history and the testimony are not often, or for many decades, are not often being interpreted or reported in an objective way, but rather than a subjective way that serve political narrative and political propaganda. But all after all, the role of the media in reporting of on the topic of the Khmer Rouge and the transitional justice process surrounding the ECCC, I think is still important. And the question is just how we should do it next. For example, after Kyosampon was convicted and his life sentence is upheld by the Supreme Court of the ECCC, or I don't know how the document is being archived, that the court spokesperson say have been documented over 2 million pages of the document. How those documents can be accessed by the journalists, by the public researcher? That's the key question next.
Thank you very much. I think that was already quite something, and it's some good talking points to delve further. I would ask you, Dr. Bernard, maybe to broaden the scope a bit and to look on the worldwide perspective. I know you don't just work on the ECCC, but on similar processes worldwide. And so would you share this view that interest is fading in the ECCC, both in the research community and perhaps globally, generally?
Thank you very much. And also, just to start with, thanks to the organizers. It's a pleasure to join this discussion with fellow experts on this. I would definitely argue and agree with my fellow panelists just now that there has been a fading interest over time, and perhaps also on an international level amongst maybe fellow practitioners, or also within the academic literature, there has been more and more critical approaches to transitional justice generally. If we reflect back at the time when the tribunal was established, or when the first discussion started at the end of the 1990s to establish this hybrid tribunal, and we look at where the research was then on transitional justice, it was very normative. It was filled with a lot of hopes and aspirations that specific mechanisms, processes, institutions could bring and deliver very big goals such as justice, reconciliation, and there was perhaps little understanding of the complexities, the challenges that come into play once these processes function. And so generally, I think the transitional justice research field has gone through this critical turn where now we discuss much more questions of power, questions of agency, of representation, and also questions of disconnects between international approaches on justice and local understandings of justice. And we see all of this also in the literature on Cambodia and the transitional justice process in Cambodia, that has become very, very rich over time. And thankfully also features more and more Cambodian voices and not just international or Western scholars. But there's a lot of critical discussion as to who has the power to define who gets tried at the tribunal, who sets the political narrative. It's an extremely selective process at the ECCC. There are a lot of discussions about political interference and the question marks over cases 3 and 4 that are raised, and also questions about the limitations of civil party participation. There was a lot of hope and a lot of interest internationally on the Cambodian case, specifically on civil party participation, because it goes much further than other international tribunals. But this was limited over time, and now also in the context of COVID, what can participation still mean for civil parties? What can participation mean when a tribunal is closing down? In the large study that you mentioned that I conducted with my colleagues, I was struck by different examples. On the one hand, civil parties who were extremely satisfied with the process, especially in case 1, because they were involved very closely in the process and felt less isolated. And the process was as important as the outcome, the judgment, the fact that they could meet fellow survivors outside of their village, engage in discussions, come to Phnom Penh, see the tribunal. But then I also met some who didn't even know whether the tribunal was still existing. And this was a study we conducted in 2018 with 440 civil parties and other population groups in Cambodia across the country. And this before COVID happened. And they weren't aware whether the tribunal was still ongoing or not. And this question for them, the achievements of the tribunal, their experiences that the tribunal had achieved justice, was questioned for them because they didn't know whether it was still functioning. So all these hopes that we had about hybrid tribunals being in the country in comparison to international criminal tribunals such as ex-Yugoslavia or Rwanda and other countries, they have become complexified and are looked at much more critically. And also this question of a hybrid tribunal, that's not just about hybrid in terms of legal traditions, as you've mentioned at the beginning, or different staff members that are there, but also different political power relations that shape these processes that are at play. So I would agree with this general trend that you just mentioned.
Thank you. So that was, I guess, the outside perspective, and you've mentioned the increasing work of research from Cambodians. We have one of such researcher here with Dr. Lee Sok Kyang, who is also quite engaged in the NGO sphere. And so my question to you would be, to some extent, is there a kind of disconnect between the national or international element? How did you perceive the work of INGOs and NGOs with the ECCC? Is there a difference in approaches?
Thank you. Let me share with you. Yeah, I will look into the perspective from my organization is quite a local one, called DC Camps. So all of you maybe know about it. So DC Camp is to compile and preserve the archives of the Khmer Rouge, and as you may know, like at least 500,000 pages of document were considered as valuable to build up legal case against the Khmer Rouge leader since the beginning. So for us, as a transitional justice measure that we are contributing, is about like back into early 2006, I think. So DCCM tried to invite at least 500 people per month to visit the courtroom at that time. So in order to make sure that people start to learn or start to know about what is going to happen at that courtroom at that time. So like thousands of people from across Cambodia, that's what we are doing, is called outreach programs. And later on, we change it to a more in-depth and more focused group by inviting only community leader or those who with critical knowledge of the Khmer Rouge history and also basic knowledge or literature, for example. So we invite them only in number like 50 people, 50. So we train them, we provide training to them, and we explain about the actual court hearing is going, like the roles of the prosecution, role of the defense, role of the co-lead lawyer, for example, roles of the judges. So those are the basics, basic start for DC camp that can help the villagers from across Cambodia. So the 50 people that we invite them to visit the actual court hearing. So upon return, so they are going to lead community forums. So we held the forums in that time, and in the meantime, we still continue to do that forum. So we qualify or train the community leaders, and then they can bring back information from the courtroom to their own village. So
And,
this is the process.
if I may, at that point, what is your experience? Do you agree with what Mr. Cheng Paron said, that relevance is slipping away to some extent, or is the feedback you get something that people are still very much interested in this work and your work?
As I do agree with Cheng Po, because Cambodian people, they care about the result, about the judgment, not the process, because the process is quite long. So that's why they have no patience, or they may be busy with their business. So that's why they care about the result. But as I'm talking from An Long Vang, during the final court hearing against Khieu Samphan, we interviewed a few villagers for my text, and many of them, they agree with the trial, but they question about if we put the blame only on the senior Khmer leader, it seems to be like what they have done so far is wrong. So the idea is that we need to raise some good point of the Khmer leader as well, because as you may know, the An Long Vang is the final stronghold of the Khmer Rouge. So that's why they have that perspective. But to me, due process and fairness are the fundamental legacies of the ECC. I think it can teach us about the significance of the rules of law in creating peace and maintain peace and promoting reconciliation in our country. And more importantly, I think the ECC play a very critical role because ECC seems try to bring to justice those who are responsible for the crimes committed during that time. But the ECC trial or judgment seem to make it clear that the junior Khmer Rouge leader, junior Khmer Rouge member can be a survivor as well, not the perpetrator at all, because only the court who say this or that person are perpetrator. So that's why I would say ECC is significant because it can distinguish between the top leaders and the former Khmer Rouge member.
But is this, let's put it perhaps on the examples of the two persons that are still to some extent outstanding, the Meas Moot and Yim Teeth. Again, I had to look because I'm really not sure if my pronunciation is anywhere near correct. So, but I would take it that you don't expect those cases to go forward anytime soon or at all.
To me, we don't know about this because we are from research institute, but we believe that the numbers of cases is not important for us, but the due process and fairness, like only a handful of individuals will try. It should be a symbol of justice that we are promoting rule of law in our country. But to proceed or not, it's the discretion of the ECC.
Thank you. I would play that again back to Dr. Bernard. You've also already mentioned the hybridity already. Do you think it worked out in the end? So there's this idea that due process has now been introduced. Do you think that the ECCC actually was able to follow due process? Do you think it worked in a way it should, or was the marriage of the national and international elements not quite as intended originally?
Thank you. That's a very broad question, and I'm a political scientist and not a lawyer, so this is more the aspect to which I can speak to. But I think there were many challenges involved in setting up this hybrid structure, and it's also important to understand that it's not just two sides, international and national judicial staff members, for instance, but also within the international group of staff members, you have those who come from a common law background and those who come from a civil law tradition. So this could be seen most starkly with understandings of the role of victims or survivors in such a retributive justice process. Those coming from a common law background from the tribunal for ex-Yugoslavia, for instance, of Rwanda, and then moving on to the tribunal in Cambodia, only perhaps saw civil victims as witnesses rather than understanding that they could play a much more important role in the judicial process as civil parties. And you had those coming from civil law background who understood this larger role of victims in a trial. So it's important also to look at these complexities and how it affected civil party participation specifically, and there are a lot of debates about that. And then when it comes to all the aspirations that were projected onto hybrid tribunals for having more capacities to have spillover effects towards the national judiciary and in that way contribute to the rule of law directly, I think there are a lot of critical assessments of this. It's certainly clear that there has been cohorts of Cambodian lawyers, judicial officials who have gone through the ECCC, who have had this very important experience of experiencing a trial in an international setting, of understanding certain things such as explaining decisions when coming to a conclusion on specific judicial questions. And these practices, I think, they will take them on as examples for their future professional careers. But then the question is, how can that happen when they go back to the national judiciary, when actually what we have seen over the time of existence of the tribunal in Cambodia is arguably a worsening of judicial independence, for instance, of how the judiciary can function independently in the current political context. So also, if you look at interns who may have come with a lot of hopes or have been inspired by judicial processes, what happens to them when they go back to the national justice system and cannot work in the same independent manner? And I think these questions, I think this potential spillover effect of the Khmer Rouge Tribunal will have to see on the long term. But at this point of time, I think the assessments are very, very critical and very disappointing.
Thank you. Jangpor, do you share that? I mean, from the way that you've flanked the process and perhaps similar processes, do you share the assessment that in this regard it has been a disappointment?
No, I can say it would be a mixed legacy. Regardless, it's a legal legacy or political legacy or justice legacy on the way that the ECCC is viewed. It can be viewed because ECCC mission is not only to prosecute the Khmer Rouge leader and finding the truth about what happened during the democratic Cambodia, but also, as I learned, it initially aimed to provide a role model for the local court as well by recruiting the local magistracy, the prosecutor and judge, and local legal staff to serve at the tribunal. It's the very idea to guide them through how the international justice process would mean, how it works, and they may return to the national court and import those models, import those best practices into the local court to improve our dubious justice system. But sadly, this mission and this expectation may not be fulfilled. Why? Because the allegation of political interference in the court process, I don't have to mention, but you can see why the case 003 and 004 could not proceed after the top leader make his public objection to the proceeding. And then you see all the stalemates. When top leader says there is no case beyond 003 or no case beyond 002, you see a lot of disagreement. Now is a stalemate at the court on whether or not the court should send Yuptet or Mirmut to trials. It becomes a stalemate, and it poses a very negative legacy for the ECCC. And at the same time, if you look at how the local judge have been involving in politically a motivated case against the dissents, against activists, I don't have to identify. You look at this factor, it's hard to me to see that how the ECCC can provide a good role model for the local court. So when the importer themselves could not function and could not get to the fullest of what the expectation of the importation of this best practice into the local court, I don't have any hope on that. But after all, ECCC need to proceed. After all, ECCC need to function and need to do at least one of its mission is prosecuting the top Khmer Rouge leader.
Yeah, okay, thank you. Dr. Lee Sok-Kyang, I had a feeling that you felt much more optimist about what the ECCC has achieved so far, being much more on the line of that bringing due process in was already a mission accomplished in itself. So let me just push you a bit on that. You would not think that pursuing future cases would help the original mission statement of the ECCC?
Thank you. To me, because we are from research institute, that's why we don't know or we have any say on this case. But if more case proceed is good, but if not, it's okay. Like, because justice in our country is quite symbolic one, and we can receive some corner of truth from the legal justice. So this is quite important for us, and we try to also try to balance by working with villagers and Khmer Rouge survivor, like who survived the regime, like 5 million who survived the regime. So that's why ECCCAMs continue to work on the healing projects that provide healthcare to those in need across Cambodia. So we have 500 volunteers across Cambodia to assist the Khmer Rouge survivor. So while we are focusing on the legal justice, and we appreciate ECCC for working so hard to punish those responsible for the genocide, but we also try to balance to work with the Khmer Rouge survivor. Yeah.
I can imagine that is not always easy to reach out and to make that connection to the survivors.
Pardon me, can you put the question again?
Yep, sorry. I just imagine that this is not always an easy task. And if you would just elaborate a bit on how you go about it, making these connections and building up this network.
Yes. As you know, like ECC could not have any specific reparation for the Khmer Rouge survivor, only symbolics. And that's why ECCCAM with the support from the US government. So we try to look for anyone or Khmer Rouge survivor who are like over 55 up to 80 or 90 who live in each village. So we try to approach them and ask them for a few questions, and if they suffer from any disease or chronic illness from the Khmer Rouge period, so we send them to a private hospital and then provide healthcare checkup every month or every quarters. So this is the process that we consider as a legacies of the, like after the ECC, we are focusing on 5 million Khmer Rouge survivor. That's what we focus. Yeah.
Mm. Thank you very much, especially for bringing up the, I think, keyword of reparations in this context, which I would like to ask Dr. Bernard if you can and want to answer. Can you give a bit of international scope on this question of reparation? Again, I'm not an expert. I imagine this question is in a similar context always as difficult to answer when I think about Rwanda or Yugoslavia.
Yes, right. I think it's one of the very difficult areas in the field of transitional justice generally, because there is understanding that reparations are often what a lot of survivors aspire to as well, or most importantly, need also to survive and to build up their livelihoods. But then there are a lot of demands for economic support in the aftermath of mass atrocities. And this is not necessarily what's often possible, especially in the context of international tribunals. So in Cambodia, it was limited to symbolic and collective reparations. And it's important to understand that all the reparation measures that were developed, especially in case 2, that they will have probably longer term effects, that the social political processes that they have started, the discussions, the topics that have been raised, for instance, also on sexual and gender-based violence, these will hopefully continue to be discussed, and there will be a longer legacy. But at the same time, I think having also seen in our study that we conducted in 2018, that reparations was one of the most criticized aspects also at the tribunal. It's important to put this into perspective with the limitations in the mandate of the tribunal, and that demands for instance, financial or economic support were not taken into account. And I think this relates to a larger discussion in the field of transitional justice that often there is an invisibility for violations of economic and social rights, and we focus much more on violations of political and civil rights, for instance, and also the measures that are developed tend to render economic measures as well invisible in the field. And I think this came out very strongly in the Cambodian context, also with the criticism that in our study there was perhaps an NGOization of the reparations process that took place alongside the ECCC, where civil parties would have perhaps liked to have a more direct say or being able to themselves implement or access funding rather than this funding to be channeled once again to NGOs who of course have their expertise and important networks in the field, but this was also an important point of criticism that was raised in our study.
Thank you. Dr. Lee Sok-Keang, this point of NGOization, do you share it? And maybe I can, without proper background makeup, open up the differentiation. Is it NGOization or INGOization?
I'm not quite clear about your question actually.
I'm sorry, what Dr. Bernard has referred to, that the NGOs have gotten a kind of, I hope I reiterate your point correctly here, have gotten in a point of medium position between the victims and the reparations, so to speak. And I wanted to ask you if you share that point, if, or even broader, do the NGOs around the ECCC live up to what is demanded of them, or do they even exceed it?
In regard to the reparation that the Khmer Rouge survivor received in the meantime, yeah, I think the Khmer Rouge survivor or civil party or complainant, they demand for the acknowledgement and a lot of recommendation for the reparation, but because of its, as you may know, it's a symbolic and collective. So that's why I think they are happy with the symbolic and collective in terms of genocide education and other outreach program to support to make sure that the genocide of the Khmer Rouge will never forget. But for the project that we are working on, it's more like, I think maybe beyond the expectation that we are reaching them and support them in terms of healthcare, and we do care about them, not only the Khmer Rouge top Khmer Rouge leader who were tried, but only the people, like both sides. So it's a model for other international court or future court as well. Like while we are working on the trial, we should consider on the other side, like victims or survivor. So that's my opinion.
Thank you. Very well put. That brings me already to the final question. I mean, we want to talk about lessons learned from the ECCC. Now, this obviously goes beyond into the international field. Dr. Bernard, do you share Dr. Lee Sok-Keang's feeling that there is a lesson learned, or what lesson learned in general do you take away from the ECCC for future such endeavors?
Thank you. That's a tough, very last question. It also comes to debating what are the measures of success for such processes. Do we go back to assessing the tribunal based on its limited mandate of trying individual senior leaders and most responsible? Is it just about that, or is it about these larger goals of justice and reconciliation in the Cambodian context? And I think that it's important when looking at the tribunal today, for me also personally, to remember just that now we can't think of Cambodia without this institution there, without the Khmer Rouge tribunal, and that to remember that first moment also that many of us personally experienced when the tribunal was set up, when the trial started, this moment of I mean, it was incredible to see senior leaders being tried for the first time. It was impossible to think about it just a few years before. It's important to acknowledge all of that, and that's now it's all of this is acquired, and our discussion has moved on and become much more critical because we've seen the process evolve over a very long period of time. And so in terms of lessons learned, I think for me, I would focus very much also on the civil participation side. And I think it's very important there to think as much of the process than just of the outcome. A lot of colleagues have written about this, that accompanying civil parties throughout a trial is as important for them, if not perhaps more than just providing a sentence. There's a lot to learn internationally about that, but also that it comes with difficult negotiations for civil parties as to what roles they're supposed to fulfill, what expectations they're supposed to abide to, what critical questions they can raise, and how emancipatory and transformative these processes can be in a political context such as Cambodia, where we see a limiting of the space for civil society and for activists and for journalists and researchers over time to raise critical questions. So for me, the question is, what's next for transitional justice in Cambodia? Will actors, civil society actors, international organizations, the tribunal, donor countries, the Cambodian government declare that it has now been achieved and that it's done, and thereby also equate transitional justice just with the tribunal and its specific mandate? Or do we understand this as a longer social political process that is much more complicated, that is also about larger questions of justice, and also looking at larger episodes of violence that go beyond just 75 to 79, before what happened, also with international actors that have not been tried at the tribunal, the responsibilities of various international governments, but also the violence that happened in the 80s and until today. So my concern is a bit about the narratives that comes out of such a very long process, and if it will then just be declared as closed and we close the chapter of transitional justice, or if the space for very important activities such as Sok-Heng mentioned also in the framework of the Khmer Rouge survivors, if these activities can continue to happen in Cambodia today and in the future, and if survivors of violence that took place not just under 75 to 79, but before and after can also be heard of as we move forward.
Thank you very much. I think this is exactly the question I would like to ask Dr. Sok-Heng now. Do you think the process will move forward? Or, I mean, there is now a general feeling that the ECCC is wrapping up in a sense. And do you think that will also mean that the wider transitional justice process will, in a way, wrap up?
Thank you. Actually, it's a long process, like legal proceeding against former Khmer leaders. It's one thing, but we still are working on other people who survived the regime. So that's why, and also other periods before and after the Khmer Rouge. So that's why DC can categorize our archive as first one is Khmer Rouge archive, and the rest can be before or after. We consider as a human rights archive. So that's why we try to use many different sources and different ways to document, to compile everything that we got. So and categorize as to Khmer Rouge archive and human rights archive. So our approach is that we continue to work with Khmer Rouge survivors because many of them have their own experience and some kind of truth from their experience. So that's why beyond the Khmer Rouge tribunal, we will try to piecing together the story from different individuals. So we focus on genocide education, Khmer Rouge survivor stories, and Khmer Rouge survivor health. So it's about healing, keep continuing, because a tribunal alone is not enough for Cambodia. Yeah.
That's a very strong point to make to conclude this, I would say. Chengpo, I have a feeling you also want to make a point on this. After your point, I would open this up for an audience Q&A. So please come forward with all the questions you may have. Yes, Chengpo.
Yes, in conclusion, I appreciate the way we discuss here on how to do the transitional justice. That back to a very fundamental question for each survivor who survived the regime. What does justice mean for each of them? How can the court do for them to make sure that they can achieve the term justice in their own definition, and that come to what our panelists have presented is very difficult. The reparation process and how the court function itself and deliver the justice to them can only be sometimes symbolic and collective, and that the key takeaway for me. But at the end of the day, the court may have its flaw. The court actually have its flaw, given the long-running process and a lot of money spent. But to me, no matter how much or whether the accused have denied the responsibility, that somehow disheartened the survivor, deny the responsibility, the involvement, and the guilt, even sending them to a detention center and to the court, and prosecuting them in a really professional judicial process, give them a really stark awakening. Why? When the accused sleep well and get up to par medical service, have decent food to eat, and still have access to information from the outside world in the detention center, it reminds them of the people who live under their rule, who could not get proper place to sleep, have no access to even the lowest standard of medical service, and subject to starvation and being blindfolded from the information of the outside world. And another point is, when the accused were granted full service to top-notch lawyer in their defense, professional court process that include the presumption of their innocence, it reminds them of the countless number of people living under their rules who got no chance to defend themselves before proper legal system, before being punished, tortured, or even being killed. So that comes to a Cambodian term that some of my fellow countrymen may have heard, like they have pchang, the term pchang. In Khmer we call defy. There are four kinds of defiance. So first is defying the anger by not being angry. Second is defying the bad person by doing good. And third is defying the stingy person by giving more. And the last one is defying the liar by speaking the truth. So at the end of the day, the court, I hope for the best for the court. And what's important next is the least we can do is the archive of the court, that I do hope it can be accessible, being in custody of a more reliable, independent institution like the DCCAM. Thank you.
Thank you. I'm quite glad that we ended the non-audience part on a more optimist note. And again, I would like everybody in the audience now to come forward. If they have any questions, just raise your virtual hand or write in the chat, and our panelists will be more than eager. Okay, Isabel, you want to be the glorious first?
I mean, I'm very selfish to take this opportunity because I'm the head of the CAS Cambodia office. But yeah, I'm happy to start and encourage also all the Cambodian and international listeners to hand their question after me. So I will pose three very short questions. First, to Dr. Lee, you told about bringing people from rural communities to the trials. So I would also want to know if you heard feedback from them, how to continue this, because yeah, when the trials are not going on anymore. I'm sure there's still a lot to bring back to the communities even after the sentences. And in which way can you imagine continuing this work? The second question would be also to one of the Cambodian speakers on the longer socio-political process. I would like to know also how everything that happened in the trials and within would be introduced to the Cambodian education system. I think this is very important, and what has also kind of coined me personally with on the German history, that we talked about it in school so much. And I think I'm seeing a lot of potential, and I would be interested if one of the Cambodian colleagues knows what the plans of the government are here going forward. And last but not least, to Julie Bernard, so transitional justice in general has seen this decline, you said, or is seen more critical also by the researchers. And I mean, on the side, we have seen the UN system also being threatened by international wars, and unfortunately still the UN hasn't managed to prevent such war crimes, genocides, or crimes against humanity throughout the world. So I would be interested to hear if you see also transitional justice crumbling in this sense, that the Pax Americana is not seen for granted or taken for granted anymore, that there are new rising powers such as Russia and China who are members of the UN Security Council and maybe have a quite different approach to transitional justice. I know this is, again, a very broad and difficult question, but I'm sure you have a take on that for us as well. Thank you.
Thank you, Isabel. I think we just go through in the order that Isabel has started. So Dr. Lee first, then Chengpo, and then Dr. Bernard.
Thank you. I would like to start with the what we are doing in the meantime. Like even before, during, and after the ECCC, we still keep working with the villagers. So in the meantime, I myself, like An Long Veng Peace Center, we focus on the former Khmer Rouge member in this community. Imagine that 55,000 people in this district, and 80% of them are former Khmer Rouge member. So our idea is that we bring people who we invite to the courtroom, because we invite commune chief or deputy chief of each commune or commune council to attend the ECC or visit the actual courtroom. So the knowledge that they experience one or twice or like many times. So our idea is that to bring them and talk to the villagers and generate discussion about the legal justice against former Khmer Rouge member. Former Khmer leader, sorry, and the perspective of the members themselves. So that's why we sometimes we receive a really bad reaction, like they don't like to see the former leader being tried, but when we keep talking, it seems to change their position by saying it's okay because they did something wrong. So it's like a mix. Sometimes they support, sometimes not. But because they say it's because of the government policy or the ECC mission to try senior Khmer leader, that's why they have to live with it and accept it. So this is the forum that we continue, we hold. And as I mentioned, like the example of a former Khmer Rouge combatant, he say we should balance with the facts and something like that, because not a mistake from the Khmer Rouge leader, something like that. So our idea is to try to understand the other side of the coin, not the Khmer Rouge victim alone, but we work with the former Khmer Rouge member. So, and we use their story and we use the legacies of the top Khmer Rouge leader. For example, Pol Pot, he died in An Long Veng, and we preserve it. as part of our mission under the Inter-Ministry Committee on the Preservation and Management of An Long Vang Historical Site. So we use it as a reflective point for youth to look into what happened and why in Cambodia at that time, why genocide happened in our country. So it's things. So and in the forum, we try to look into beyond, like as Chin Pua mentioned, like it's a model, like ECCC, it's a model of justice. So we say what we can learn from the ECCC process. For example, is it possible that it can strengthen our rule of law, for example, and how it maintain peace and promote reconciliation, something like that. And beyond that, we also look into the problem and challenges facing their community. So we try to look into their perspective from village to village.
Thank you.
In terms of education, ECCM is working on this for a long time, and we also introduced a new book called Comparative Genocide. We focus on other cases like Armenian case, Rwanda case, Bosnia-Herzegovina's case. It's a major try to expand the knowledge of our school children beyond our case.
Thank you very much. And of course, that was a question that warranted an in-depth reply. But unfortunately, I would ask the next two panelists to keep themselves as short and concise as possible so that we may have some other audience questions. So if I remember correctly, the next one was Dr. Bernard.
I think the two first questions were also for the two Cambodian panelists.
Okay,
but
then
I can also
well, you're already speaking. I would say
okay,
please
sorry.
continue.
For the sake of time as well. Right, internationally, the perceptions of transitional justice and the transitional justice field in the current geopolitical context. From what I have, perhaps I can also illustrate that with the case that I'm working on, the context I'm working on now, which is Syria. Very clearly, we also see all these questions that you have raised, Isabel, the loss of credibility of the UN, the rise of different actors, especially in the Syrian context, taking on roles in peace building, in mediation that weren't there before. Then I would argue, however, that a lot of the geopolitical challenges we face today also apply to the Cambodian context many years ago. So we also had experiences of a lack of credibility of the United Nations and whatever we understand under the international community in a lot of conflict contexts before today. But what we see in the Syrian case is, for instance, that the notion, the word itself of transitional justice maybe has become very criticized. After the uprising, there was a lot of hope for transitional justice. There were demands for transitional justice, attempts to set up strategies, because the hope was that a transfer of power, a political transition would be imminent, and that has not happened. And so since then, the notion of transitional justice itself is very criticized, and Syrian civil society actors in exile would not necessarily use it because there has not been any transition, and what can it mean in the current political context? But it doesn't mean that the aspirations that underlie the work in this field are not still there, that there is not this aspiration for justice, for peace, for democracy, and that there are not also actors who are trying to find new ways to challenge the problems linked to the blockages of international established avenues for international criminal justice. The International Criminal Court is blocked in the Syrian context. We cannot try Assad there. We cannot have an international or a hybrid tribunal in Syria. But there are countries in Europe and lawyers, Syrian and internationals, who are working together to bring cases, for instance, in Germany, in Europe, of Syrian alleged perpetrators who are now in Europe, and who are facing trial for the crimes that they committed in Syria under the principle of universal jurisdiction. So there is a changing of this international architecture of transitional justice in international criminal justice. And there is a criticism maybe of the notion itself, but of course not of the aspiration and the efforts that are being put to address these demands for justice.
Thank you very much, Chengpo. The last question is yours.
I think I'd like to address the question about genocide education. I would like to highlight the role of the ECCC, the DCCAM as well in working. As far as I know, they are working with the Education Ministry on genocide education. That a really good start from prior the cooperation. The Ministry of Education run by themselves. They have their own documents, and now they incorporate with DCCAM. If I'm not wrong, Bong Kieng can clarify on that, and that's a good start. But material, when you talk about education, genocide education, to me personally, I believe two important things matter. First is the material. We need to make sure that the content, the textbook is relevant, is up to date, is diverse, to ensure that all highly qualified sources, historical document is included. Not only from the perspective, I don't want to have to see an education system like the history is written by the winner, but want to have an genocide education system that have the material that is written objectively, and secondly is the methodology as well. So it's not only with genocide education, but it talking to the entire education in Cambodia. It's about how we should teach the student. It's just asking them to memorize events, dates, actors, and then ask them in an exam, or should we ask them in a more critical question, giving them more freedoms to write critically about what they think, and let them researching evidence, external material that is highly qualified to back up their claims. So these two things important, and I hope it can be achieved with both the material and the methodology for teaching education, especially for not only for history teacher, but the teacher of other fields should be well equipped with this kind of, the acknowledgement that the material and methodology matter, that should be innovative.
Thank you very much. At this point, I would quickly ask you, again, apologies for the technical delay, but in order to also allow Udom and perhaps someone else to give another question, if you would be all right with going 5 minutes over time. I hope that would be okay. Udom, I would invite you to ask a question.
Thank you so much, Mauricio, and thank to our three distinguished speakers. Very, very insightful input on this particular topic. Well, it's me, Udom from CAS Cambodia. Before asking a question, I want to do a very short reflections on the tribunal or transitional justice in general. If you look into the case of Rwanda, the International Criminal Tribunal for Rwanda cost, for more than a decade, $1.3 billion to process the transitional justice for that particular country. And the last case was dissolved in 2015 December with the missions incompleted. And the International Criminal Tribunal for former Yugoslavia was cost for $2.3 billion as well. And the last case was dissolved in December 2017 with the mission map incompleted. And it is likely as well for the ECCC to be dissolved at some point without the missions is completed as well, especially the very last two cases, which we all know about the arts together, about the influence, all of those stuff. So to this personally, I think that transitional justice is costly, and it's very costly in those particular country or those particular contexts. So my question would be asked directly to our Cambodian speaker, Dr. Sok Kieng and Bong Cheng Po, is that, do you think it is worth it to spend that huge amount of money to somehow bring the transitional justice to one particular nations of victims? That's be my first question to both Cambodian speakers. And to Dr. Bernard, is there anything we can do more to make the cost spent more effectively, both on the national level and international level? That would be my questions. Thank you.
Thank you, Don, for a very good question, I think. And I would first put it to Dr. Lee Sok Kyang. Again, please try to be as quick as you can be. Well, please.
Thank you. It's a big question. I cannot provide a really short, the right answer and perfectly. But I think transitional justice is a mechanism that we work together, just not only DCCAM, but also other institution, individual or institution. So we work together, and it's a matters of wound in the survivor. So that's why it takes a lot of time. That's why you say it's costly. It's right, but we still work out. We try our best to heal our country. So to heal our country, it can be through many different mechanisms like education, legal system like this, and other means. So that's a very quick one. Thank you.
Thank you. And I apologize for forcing you to do what is every researcher's nightmare, to be too fast, but still, I think you managed very well. Dr. Julie Bernard, do you want to take over your question and then Chengpo?
Yes, thank you very much. It's a very complicated question, and I think we can talk about the specifics of the ECCC budget, and then there are people who are more able to respond to that, and we can have a discussion about the discrepancy between, international salaries and Cambodian salaries at the tribunal. Should we be ready to work for less money to be able to have less expensive trials? At the same time, even if the ECCC was probably, it has been calculated to have been the most expensive trial per defendant, because there were so few defendants in comparison to Rwanda or ex-Yugoslavia. We're talking about such a large period of time, such a complicated Khmer Rouge regime. So it's taking a lot more time than expected, and it was necessary as well. But I would say that it puts the question of priorities in spending and transitional justice to the forefront. Is this money best spent on a tribunal, or should we better spend it in terms of distributing individual financial reparations to civil parties, survivors, or other processes? And I think this is at the heart of transitional justice processes, and it's the most controversial and complex question, setting priorities and understanding that money goes with it, and then other processes cannot be funded anymore. Thank you. I think I will leave it at that.
Thank you. Chengpo?
Yeah, I still stand by my view that it's overspending. That the cost is too high, and the process took too long. And I'm not sure how the court initially expect that the process would take only 3 years at the start, and now it takes, if you count when the court actually started in 2006 until now, it's 15 years and $330 have been spent. I still think it's too long and too much spending, but we'll keep an eye on the outcome and how the history will judge the legacy of the ECCC themselves.
Thank you very much. If anyone has one very short question that can be very concisely answered, now is your time to step forward. Otherwise, I think it's time to conclude. I think that probably means that, well, in the best case scenario, you have answered all questions, which would be nice, but I believe that we've tried to cover such a breadth of territory today that perhaps this should more be the kickoff point for an entire series of events in the future. So let me please say thank you again to you, our dear panelists, and to all our guests who could make it. I apologize again profusely. We practiced every step, but still, if there's a spanner in the works, there's not much to be done. So I'm really happy that so many of you could make it nonetheless, despite the technical issues. We will try to collate some of the lessons learned that we've discussed today into an event report, without mentioning names and everything. So you will find that on our website in the hopefully near future. So a colleague will probably share now the links to our website and social media. So please follow us there to stay on track with what we're doing, and we're hoping to do much more on the ECCC and transitional justice in Cambodia in the future. Now, I would, as I asked you to do in the beginning, please ask you to open your cameras now, because we would really like to have a final photo shoot. Stephanie, could you unpin our panelists so that we have the gallery view? Thank you. So wait a second more. Please turn on your cameras. Thank you. Okay. That is not, I think that is enough. And then it's completely all right. I get that there are sometimes reasons for not doing it. All right. So 1, 2, 3, click. And thank you very much for being here with us. And I wish all of you a good start into the week and hope you have an enjoyable rest of this Monday. Bye-bye.